friends, I'll take you through the chapter Payment of Gratuity Act 1972. This chapter is a part of IPCC Paper 2, Law, Ethics and Communication, and it's numbered as chapter number 5. As for myself, I'm C.A. Paridhi Sinha, your mentor for this chapter. What exactly are the objectives related to this chapter? See, the main intention of the Payment of Gratuity Act is to enforce the provisions related to gratuity. What's gratuity? Gratuity is a retirement benefit which is provided by the employer to the employee. Thus, the main objective in this chapter is to learn that which employers are liable to pay gratuity and which employees have a right to claim the same. Only those employees who are defined under Section 2(e) would have a right to claim gratuity. Over here, an employee would mean any person other than an apprentice who is employed in any factory, oil field, railway company, any mine or major port, any shop or establishment, for any skilled, unskilled, supervisory, technical, administrative, clerical, and managerial work. Now, who would be the employer who would be liable to pay gratuity? Well, the employer has the same meaning as what is given in the Payment of Bonus Act 1965, so you can refer to the same. Now, let's consider what are the specific establishments to which POGA applies. There are 3 broad categories and let's consider them step by step. Section 1 states that Payment of Gratuity Act is applicable to the following establishments. Point number 1, any factory, oil field, railway company, mine or major port. Secondly, any shop or establishment with minimum 10 employees. A point to be noted here is that once the number of employees exceeds 10, POGA continues to be applicable even if the number of employees goes below 10. POGA is also applicable to any other establishment which is notified by the appropriate government in the Official Gazette. Now friends, what if one establishment has a number of departments, undertakings and branches? See, the question over here would be that would we consider these departments, undertakings and branches separately or as a part of the same establishment? I'm sure that you must be convinced that departments, undertakings, branches are a part of the same establishment, provided they would have a common profit and loss account and a balance sheet. However, their location is irrelevant. Now, what about salary or wages? According to Section 2, wages are all the payments which are received in cash, including dearness allowance, but excluding certain items. Now, what are those items? Commission, overtime allowance, bonus, house rent allowance, and any other allowance would be specifically excluded for determining the amount of salary or wages of an employee. Now, something about continuous service. You would get an out-and-out theoretical question stating that yes, what are the rules regarding continuous service? Hardly 5 points and your answer is done with. Point number 1, the employer would be liable to pay gratuity to the employee provided the employee has completed at least 5 years of continuous service. Now, the above condition of 5 years is not applicable in case of death or disablement of the employee. Also, continuous service would mean uninterrupted service. The following days on which the employee is absent will be assumed or deemed to be a part of his continuous service. So what are those days? The days on which he is absent due to any sickness, any accident, any leave with salary, strike, lockout, laid off. Laid off means that he is willing to work but he is prevented. Or any other day on which he is absent due to no fault of his. Let's consider another concept related to nomination. Basically, gratuity is paid to the employee, but however, on account of his death, it is paid to the nominee. The nominee is a person who is specified by the employee in a particular form. It is given that on account of the death of the employee, the amount of gratuity should be paid only to that particular nominee mentioned by the employee. More than one nominee, along with a proportionate distribution, is allowed to be named. The nominee has to be only a family member. But then see, it's so obvious. If the employee does not have a family, then any other person could be the nominee. However, when the employee acquires a family, then he would be required to make a fresh nomination. If the nominee dies before the employee, then the employee would be required to make a fresh nomination.
Now, something about the concept of family. Now, why family is important? Because we've earlier checked out in the concept of nomination that the nominee has to be a family member. So now, some more explanation about who could be a part of the family. Family depends upon the gender of the employee. In case of a male employee, his family would include his wife, his children, the widow and the children of his deceased son, his dependent parents, and his wife's dependent parents. On the other hand, in case of a female employee, her family would include her husband, her children, the widow and the children of her deceased son, her dependent parents, and her husband's dependent parents. Now, this is the most frequently asked question from this particular chapter, calculation of gratuity amount. Section 4 provides the above calculation which depends upon the type of employee. Firstly, in case of employees of an establishment which is not a seasonal establishment, the gratuity amount would be equal to 15 days' wages for every continuous year of service in excess of 6 months. Now, what do we understand by a continuous year of service in excess of 6 months? See, if the employee has worked in the establishment for 6 years and 10 months, then it would be considered as 7 years. If he has worked in the establishment for 6 years and 5 months, it would be considered as 6 years. And lastly, if he has worked in the establishment for exactly 6 years and exactly 6 months, it would be considered as 6 years. Alright? In respect of piece-rated employees, the gratuity amount is equal to the average of the last 3 months' wages which are preceding his termination. Now, something more about calculation of gratuity amount. In respect of monthly rated employees, the gratuity amount would be equal to 15 upon 26 into the continuous years of service in excess of 6 months. In respect of employees in a seasonal establishment who are working throughout the year, the gratuity amount would be 15 days wages for every continuous year of service in excess of 6 months. And lastly, in case of employees in a seasonal establishment who have been working only for part of the year, the gratuity amount would be equal to 7 days of the wages for every season. The last concept related to gratuity is forfeiture of gratuity. Now, what we understand by the term forfeiture is that the employer will have a right not to pay any gratuity to the employee and even the employee will lose the right to claim gratuity. So what are the circumstances under which there could be forfeiture of gratuity? In the following cases, the employer has a right to forfeit the gratuity amount. If the employee is terminated due to any misconduct, if the employee is terminated due to any act of violence, if the employee has caused any kind of damage or loss to the employer or committed any offensive act. So friends, all the concepts which were related to gratuity have been explained in the order of the sections of the Payment of Gratuity Act 1972. All the theoretical concepts have been combined with practical case studies wherever possible. And for best results, you could prepare a list of sections for your revision and future reference. So, all the best and happy studying! So friends, this is CA Paridisana signing off, and thank you so much for being a fantastic audience.